As we've discussed in other videos, Schedule A cases generally involve intellectual property infringement claims. And among these, trademark-related claims are the most common. These claims will usually include those brought under the Lanham Act, such as federal trademark infringement, where there is a registered trademark at issue, and unfair competition. A plaintiff may also bring analogous claims under the law of the state in which the federal court sits, such as violations of the state's Deceptive Trade Practices Statute, common law trademark infringement, and unfair competition. All of these claims are based on the same basic elements. The defendants are taking advantage of the plaintiff's commercial goodwill by misappropriating the means by which the plaintiff identifies its products to its customers. An e-commerce seller can be at the receiving end of these claims in a few different ways. Most commonly, the seller uses the plaintiff's trademark in a product listing title or product description. The plaintiff's AI or other investigatory tools pick up this public-facing text when scanning product listings. Secondly, a scan can detect word marks and logo marks within product listing images. So even when a seller is careful to avoid using protected trademarks in product listing text fields, utilizing product imagery taken from suppliers, such as 1688.com, can create risk. Occasionally, a plaintiff may bring a trade dress claim where the accused products have some source indicating product or packaging configuration. Where a defendant has a standalone website that incorporates the plaintiff's trademark, there may also be separate cybersquatting claims. Remedies for trademark infringement can include the plaintiff's damages and the defendant's profits from the accused activity. The availability of a defendant's profits is important, as this will justify the asset restraint component of a temporary restraining order, usually at least up to a defendant's revenue from the accused products. Where the plaintiff's trademark is on the principal register and the accused products are covered under the plaintiff's registration, that is, the activity is counterfeiting, as that term is specifically defined under the Lanham Act. The plaintiff may elect to receive a statutory damage award of up to $2 million. Statutory damage awards should bear some relation to the scope of the accused activity, though the prospect of a large award is what motivates much of a plaintiff's behavior. Attorney's fees and costs are available under the Lanham Act in exceptional cases, but may be more easily awarded under state laws. Of course, the Lanham Act and its state analogs will allow for an award of a permanent injunction to usually affect the permanent removal, by the defendant's platform primarily, of accused product listings. Defenses to trademark-related claims in Schedule A contexts can include nominative or statutory fair use. Plaintiffs may wrongfully involve a defendant who simply used a term to describe the characteristics of the product in question in some comparative way, or saying the seller's product is compatible with another product. Also, a plaintiff's trademark may be weak or have a registration that is vulnerable to challenges. If a defendant does not have any consummated sales of accused products into the court's forum, that can be a basis to dismiss the lawsuit at the outset of the case for lack of personal jurisdiction. Where a defendant does not appear nor respond to the complaint, a default judgment will usually be entered in which the plaintiff will obtain a statutory damage award and a permanent injunction. Where a particular defendant's sales of accused product are very large, the plaintiff may eschew the statutory remedy and opt for the defendant's profits which, absent the defendant appearing to introduce evidence of costs to arrive at profits, will be assumed to be all of the revenue. Attorney's fees and costs are typically omitted from default judgment orders. Sellers must be mindful of terminology and imagery they obtain from third-party suppliers or elsewhere online. Very often, lawsuits involve trademarks which are somewhat innocuous and not well known, and the risk of litigation is overlooked. Being familiar with trademark rights, enforcement strategies, and potential defenses is essential to safely and successfully navigate e-commerce environments and grow your business.